Good morning. I'm Guy Bailey. I'm the president here at the University of Texas, Rio Grande Valley. Yeah. Thank you, and thank you for being here. We're really honored today to host the Supreme Court of the state of Texas here in the Rio Grande Valley, and we're grateful for this opportunity that this brings to our community. You know, this is a rare opportunity. Has anybody here heard oral arguments before the Supreme Court before? I haven't. Very few people have, right? And so it is a very rare occasion. And today is special because we have so many students from across the Rio Grande Valley here. And there's a wide, I think we have everybody from junior high students to university students. And this is a great opportunity that they'll remember for the rest of their lives. And they'll learn that this is just not about, and what you'll learn here is this is just not about the practice of law, but inspiring the next generation of our students who are going to be in your shoes at some point and in their shoes as well. So watching the court preside over oral arguments is a very rare thing indeed. And by the way, I think this is the largest audience in the state of Texas to have watched oral arguments, I think, when everybody gets in here. So they're not through coming in here yet. So, and I hope it sparks your curiosity, deepens your understanding of the justice system, and encourages you to imagine, if you're a student, what you can do later in life. To our community partners, educators, and students, thank you for being here. We're proud to share this moment with you, and as always, to serve the Rio Grande Valley. Welcome to this historic day at SaveRGV. Thank you.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. Welcome to this very special sitting of the Supreme Court of Texas. My name is Jimmy Blacklock. I'm the court's Chief Justice, and we are delighted. I want to say on behalf of the entire court, we're so happy to be here with you at the University of Texas, Rio Grande Valley. The court travels occasionally for arguments, and I want to say this trip here has been one of the best trips that we've ever had. We've been treated so well, and this may be, it certainly is one of the largest crowds ever to witness a Texas Supreme Court argument. And we're so happy that each of you is here. Our thanks to everyone who made this trip and this hearing today possible. Our thanks to the attorneys who have traveled for the argument. And again, our very special thanks to each one of you for being here with us today, this morning, to see your Supreme Court in action. And this court exists to serve you, the people of Texas. And that means all the people of Texas in every part of our state. To each one of you, again, we're very, very glad that you're here with us. We will hear argument in two cases this morning. As you'll see, these arguments are an opportunity not just for the lawyers to make their case to the court in person, but they're also an opportunity for the justices to ask questions and to engage in a conversation with the lawyers about the cases. As many of you know, the primary way in which these lawyers will present their cases to the court is in writing. And these parties have already done that. The court's familiar with their written presentations. We call those written presentations briefs. And all the briefs supporting today's arguments are available on the court's website. And if you'd like a deeper understanding of what you're about to see today, I encourage you to take a look at those briefs if you haven't already. And if you have already looked at the briefs supporting today's cases, big bonus points for you. Today's first argument will involve three closely related cases that have been consolidated together for one argument. Those cases are case number 240237, the Texas General Land Office versus SaveRGV, case number 240407, Cameron County versus SaveRGV, and case number 240547, the Attorney General versus SaveRGV. We will take a short break after the first argument, and then the second argument will be in case number 241060, the State of Texas versus the City of McAllen. The court has allotted 20 minutes to each side in each of the cases. These arguments can be viewed live online and will be available recorded on the court's website later today. With that, we are ready for argument now in the consolidated cases.
May it please the court, Ms. Klessman and Mr. Allison will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Ms. Klessman will open with the first 9 minutes and will present the rebuttal.
May it please the court. The Open Beaches Amendment to the Texas Constitution does not guarantee every person access to every Gulf Coast beach at all times. The interpretive tools that this court uses to analyze the Constitution demonstrate it is a more limited right. The question, of course, then, is what are those limits? And because the right that is granted is that of an easement, we go to the fundamental rule that all property is held subject to the valid exercise of police power. House Bill 2623, which is what is at issue here, falls well within that power because it protects individuals during rocket launches and also furthers the state's interest in the space industry. So for these reasons, we're going to ask that this court reverse the Court of Appeals and find that this law is constitutional.
There were a number of standing issues in the lower courts. Have those dropped out of the case now?
Which specific issues, Your Honor?
Standing,
Oh,
associational
standing. I'm sorry. I thought you said outstanding issues. Yes, we have not pressed a standing argument before this court. So the court, yes, the Court of Appeals found there was sufficient evidence that the individuals at these organizations traveled to the beach, and so we have not pressed that at this time.
So in the lower court, the state pressed an interpretation of the subsection D, private right of enforcement related to the standing issue. Could you articulate the state's position on what subsection D means when it refers to a private right of enforcement?
Your Honor, the state did not join that argument. Mr. Allison is going to be presenting the argument on the private right of enforcement today, so I am going to be focusing on the meaning of the rest of the Open Beaches Amendment. So we did not join that portion of the brief, so I would hopefully refer you to Mr. Allison for that, but yes.
Does the state disagree, or are you just not taking a position?
What I will say is we did not join that portion of the brief, and we did affirmatively abandon that argument in the Court of Appeals. But turning first to the text of the Constitution, if we look at subsection A, which defines what a public beach is, it defines it in terms of property. There's a lot of words, but it comes down to an easement by dedication or prescription. And then if you look at subsection B, it says that the right granted by this subsection is dedicated as a permanent easement in favor of the public. So that is what we're talking about. We're talking about a property right. And with that comes the common law rule that all property is held subject to the valid.
So do you acknowledge that there is a line somewhere? Even if you're talking about a rational basis review, or is there, that's my question, as to what the state, when the state would be going too far?
Sure, Your Honor. I think based on the history of the amendment, we could say obviously if the state were to sell the land and eliminate access to the beach, that would be too far. When we're looking at the police power, other constitutional amendments obviously limit the exercise of the state's police power.
What if it doesn't sell the land, but it does eliminate access to the beach?
I think under the reading or the understanding of this law or the amendment at the time it was enacted, I would say yes, eliminating access to the beach would violate.
So in theory then, if it was necessary for the operations, space-related operations, to require 365-day closure of the beach to the public, that would violate Section 33?
I guess I will sort of hesitate on that. I think if the state were, again, sort of to sell and eliminate it, that would be a problem. I hesitate just to do line drawing. I think 365 days probably would exceed the police power in this case, given the obvious interest of the people in enacting this amendment and putting it in the Constitution. But we're nowhere near 365 days.
Well, if there is a line, though, then isn't it a little premature for us to resolve the constitutional question?
Well, they have brought a facial challenge, so that obviously can be resolved right now. If there is a constitutional application of the statute, then the facial challenge should be dismissed. And their as-applied challenge at pages 108 to 110 of the clerk's record is just as applied to Boca Chica Beach. So we're not in an as-applied circumstance where the state is shutting down Boca Chica Beach for 365 days.
Maybe it's not premature for the Court of Appeals to address it, but I guess in the posture that we get the case, where your lead argument is that the Court of Appeals didn't apply the right standard, didn't analyze the constitutional question correctly in light of the immunity claims, isn't it maybe premature for us if you tell us, well, at some point, yes, it's too much. There's some debate about how much this is and whether this is too much. You know, is it 364 days, 363 days, go all the way back? It's not possible for us really to reach your second issue and resolve the case, is it?
Well, to the extent their as-applied challenge is based on the facts on the, like, again, their as-applied challenge was only limited to as applied to Boca Chica Beach. They did not make an argument about number of days. So I would point the court to what you did in Perez and say, we don't have to draw the line, we just have to decide what's in front of us right now. And what is in front of you right now is not 365 days. It is something, obviously the circumstances have changed since this lawsuit was filed 5 years ago.
But you know very well, because you advocate in our court quite a bit, that this isn't just about this case. That's the reason Justice Young's question is really vital.
And certainly, Your Honor, and the court has explained in cases involving the exercise of the police power that those are very fact and circumstance specific cases. Obviously, a violation of the Constitution would be outside the police power of the state. And then in Turtle Rock Corporation, this court explained that you can also look at it as sort of a two-step process. The regulation must be adopted to accomplish a legitimate goal, so the health, safety, welfare, and it must be reasonable and not arbitrary. And
When we are thinking about reasonableness, I wonder if you would help me with how to conceive of the easement that we're talking about. The briefing and the conversation is about Boca Chica Beach in particular. But does the Constitution give an easement for that particular beach, or is the easement across the state, meaning along the entire Gulf, in which case Boca Chica is a pretty small piece of the easement? So I think that matters to reasonableness.
Right, I agree.
So is the state's position that you could close Boca Chica 365 days a year as long as you weren't closing other beaches?
I think that would, I hopefully do not have to argue that to you someday, but I think those would be the factors you would consider. Because to your question, Justice
Is there
Huddle.
one easement that spans the entire Gulf, or is there a series of easements and Boca Chica is its own easement?
What is defined as a public beach is an easement by prescription or dedication, and as this court held in Severance, that means you do actually have to have established the easement, and so you're going to have to look at each portion of the beach. For example, Severance's property probably doesn't have an easement on it anymore, and so it's just, you're gonna have to look at each piece. There's no question in this case that there is an easement on Boca Chica Beach, and I imagine most of those 367 miles do have an easement on them, established by use or prescription. But, so that's how the Constitution looks at it. You do have to look at the individual piece, but the easement is, you would just look at it, probably extends most of the coast, but there are going to be portions probably where it has not been established.
So the Constitution uses the word unrestricted to describe the public's use of the easement. Why don't we need to give some effect to that word instead of just saying, well, it's whatever easement you would have at common law? And if we do need to give some effect to that, what's your view on what unrestricted means?
I think unrestricted is sort of a separate question from the police power. So the easement that is granted.
Why shouldn't it be read as a limit on the police power?
Well, I would point this court to what it said in Lombardo. It's quoted in our brief, but I think it's worth mentioning again. It says the insistence that the right of property or the unrestricted use of property is not subject to the police power has long since been determined adversely to that contention. So I could give someone the unrestricted use of my backyard, but the cities can still come in and say you can't put a gas station there.
Counselor, is it OSG's position that a Texas citizen could just murder somebody on a Texas beach because of the open beaches provision of our Bill of Rights?
That is not our position,
Right,
Your
I
Honor.
understand that. One other question, I apologize that your red light's already on. Justice Lerman asked a good question about kind of where's the line. I don't remember seeing it in the briefs, but I may just be forgetting. Does our Constitution's takings clause in Article 1, Section 17, I know that you were at OSG during severance, does the takings clause tell us anything about where a doctrinal line might be for something like this or not?
I don't believe it does, Your Honor, at least under our conception. The court last year in Commons versus Lake Houston emphasized that the exercise of police power is a separate question from whether or not there has been a takings. And so, obviously, a taking is the exercise of the police power. So they interact, but I don't think they really tell us what's happening here because we're not taking, this has not risen to the level of a taking. It's just temporary closures at the time.
Thank you.
Ms. Klusman, on the immunity waiver, can you articulate a line separating facial invalidity from merely wrong or unpersuasive?
What I would say as far as facial invalidity goes is if the claim is going to fail as a matter of law, then it is facially invalid. I think that's, the court has not adopted sort of a 12b6 idea here, but I think it is similar to that. If no matter what the facts are going to be, if the claim is going to fail, then there's no point in spending additional resources defending it, and so it can be dismissed.
It just seems like that's turning a merits question into a jurisdictional question. It's just asking a court to decide if the claim seems weak, and if so, then there's no jurisdiction. Does it make sense to conflate those two like that?
Well, the court has, and I do apologize if I may continue. The court has recognized in cases such as Town of Shady Shores and I believe Milk that oftentimes jurisdiction and the merits are intertwined. And so you do have to consider merits to the extent you need to do to determine your jurisdiction. And in footnote 9 of Milk, you said you do that. You consider it as far as is necessary to determine whether or not repleading should be permitted. So if the claim is going to fail as a matter of law, there's no need to replead, and we should end the case now. If there's some reason that the claim might still succeed, if there are disputed issues of fact that go to the merits, then the claim could move forward because it is not then facially invalid.
Any further questions? Thank you, Ms. Klisman. We'll hear from Cameron County.
May it please the court. Article 1, Section 33 of the Texas Constitution, the open beaches provision, contains a remarkably unique subsection. Subsection D states that this section does not create a private right of enforcement. This language is not found in any other part of the Constitution, nor is it found in any other state statute. It has not been construed by any court before this case. In these cases of first impression, we look to the precedents of this court to establish the meaning of this section. And first, we must assume that the writers of this provision intended the words that they placed. And we must give those words their common meaning in absence of any ambiguity.
So it says does not create a private right of enforcement, but in your view, does it bar other private rights of enforcement that may exist?
I think that it preserves only the state's right of enforcement because it says it does not create a private right of enforcement.
Right, it doesn't create one, but does it destroy one that exists somewhere else in the statutes?
Well, first of all,
For example, the Declaratory Judgments Act.
right. Of course, the Declaratory Judgment Act does not confer jurisdiction.
Well, but this isn't a question about jurisdiction. This is a question about whether there's an action. That's a merits question.
That's right. But I think that we must find, if there is an action under the Constitution, then we must find that jurisdiction in the Constitution.
So you do think it destroys other statutory rights of action?
I think it creates an exception in which there is no other cause of action other than the public's cause of action. It does not create a private right of enforcement. So if we look at the plain language, I think the meaning becomes clear.
Some might argue that the lack of a private right of enforcement that you're advocating for renders the provision useless because it can't be enforced. What's your response to that argument?
I think that that's incorrect because there remains the public enforcement. There are other instances in our jurisprudence in which only the public can bring an enforcement. Writ of quo warranto, of course, obviously the criminal law, a removal action under Chapter 87 of the Local Government Code. All of these are actions that can only be brought by the public officers and entities.
If it is the government, the state, that is alleged to have violated the Constitution, and the state is the only actor charged with a private right, or with the right of enforcement, how do we remedy the state's violation of the Constitution? Are you saying that the judiciary is powerless to remedy that?
I'm saying that we can only apply the language in the Constitution that we're given. And the language here, I think, clearly shows that the legislature who crafted this language and the people who approved it understood that in the absence of some language like this, there would be a private right of enforcement. By placing this in Article 1, they created the presumption that in the absence of this language, there would be private litigation over the meaning and application of this provision. They obviously wanted to prevent that. Therefore, they reserved the right of enforcement to public entities.
Under your understanding of this provision, could Cameron County or perhaps another local government whose citizens were affected sue the state in order to enforce its citizens' right to the open beaches?
I think they certainly thought about that the state might need to enforce the public's access to the beaches against not only private individuals who might infringe on that right, but local governments as well. So certainly the Attorney General, the General Land Office, has the ability to enforce this provision. Private
But
individuals.
my question is whether a local government could sue the state if it disagreed with the state's closure of the beach. And would that be a private right of action?
We don't have that case before us, but certainly in most cases, a political subdivision does have the power of the state in order to bring an action.
Why is that now? Your local governments don't enjoy any sovereignty. You have what the sovereign state of Texas has given to your client, the county. So why would it run uphill? Why would a local something local be able to sue the sovereign state of Texas?
Of course, that situation is not arisen, is not here.
No, I know. That's why it's a
Yeah.
hypothetical question.
Exactly. And I don't foresee, that occurring, but I think
I think
we
it's
have
an-
to foresee
it's an
these
important-
things.
I think the state would claim immunity as it does in this case.
I think it's an important question. It might be useful to have your position on it and have the state's position on this question in general about the private right of enforcement, and also the question of whether the prohibition on a private right of enforcement would prohibit a local government from asserting these provisions in court, such that if that's the case, then there would be at least a political outlet for people to urge their local government to assert the Open Beaches Act on their behalf.
Yes, and I would agree that certainly stating there's no private right of enforcement does not exclude any public entity, including a political subdivision, from seeking to assert a cause of action under this provision. Correct.
Any further questions? Thank you, Mr. Allison.
Thank you.
We'll hear from the respondent.
And please, the court, Ms. Morales will present argument for the respondent.
Good morning. May it please the court. When the government closes the beach under its HB 2623 authority, it does so at the request of SpaceX so that SpaceX can take possession of the beach, exclude the public from it, use it as its blast zone for its spaceflight activities for as long as it wants, whenever it wants. In short, the government has given this beach
So
to...
let me ask you, so you agree, I assume, that the state does have the police power to do certain things to protect the public, right?
That's correct, Your Honor. We
And-
do concede that.
Okay, and so in light of the state's acknowledgement, sort of, that if that beach were closed, every day of the year, that may not pass. And so why is this use of the police power, which seems to be legitimate, having to do with space-related things that we all think of as being protective, why is that different?
Certainly, Your Honor. So the police power has a specific analysis that is contemplated, and that's been spelled out, for instance, in the Robinson opinion that this court issued. And when we apply that analysis, we look to the plain text of the Constitution, and we look at its history, we look at its structure, and when we do that, we can see that the purpose of this constitutional amendment was to provide an unrestricted right. And so...
But it's not unrestricted. You just said it was not
correct,
unrestricted.
and there are limits, certainly.
And so that's my question.
Yes.
Where's that line?
I can't explain, I can't specify exactly where it is, but I can say it's not this, and here's why. Because here what we have is a beach closure to facilitate the very risky, hazardous activity that puts the public in danger in the first place.
But there's a lot of things that the government would do, like, investigate what type of nuclear this or that is. So that's, I
Right.
don't know that that's a sufficient answer.
So The examples that have been provided by the state in their brief, such as a hurricane or an oil spill or maybe a nuclear disaster of some sort. In those cases, we agree that once one applies the Robinson analysis, it's likely those do satisfy the test to show that this is a valid exercise of police power. In this case, the state hasn't conducted that analysis in the first place. They haven't even cited Robinson, for one. Two, the interests that they have articulated that are satisfied by this statute are things such as maintaining Texas as a private space hub. Though that's not.
So to that end, is this case really about mediating uses among private citizens? So if I reserved a beach pavilion for a birthday party from the local government says it's yours to use from 2 to 5. And so for that period of time, I had the exclusive use of that part of the beach, or at least the pavilion. Why is it not within the ambit of local government or the state to mediate uses between and among private citizens, so long as that answer is rational and takes into account everybody's interests?
So that is allowed in some respects under the Open Beaches Act. The county can exercise its authority to require permits for mass gatherings, but the statute also says that they must do so in a way that doesn't restrict access to the beach. And so the legislature has enacted some regulations with the knowledge, understanding, and respect due to Amendment 33.
But doesn't it say both? It does say right of ingress to and egress from, but it also says right to use.
That's right.
And I understand that it says unrestricted, but to Justice Bland's question, I'll give you a hypothetical. Suppose we're at the beach. I'm going to be grilling, so I've got a little bit of fire going, and say Chief Justice Blacklock is going to be playing volleyball or something, and we both want to use the same sand, and my fire is getting a little out of control. To Justice Bland's point, the police power still allows to mediate between those private uses, yes or no?
Yes,
Okay.
I think that
now,
that would be.
instead of a Weber grill, what if the fire is a little bit bigger, and maybe it's a big green egg or something, and then so on and so forth until it's a really, really big solid fuel booster fire, and we probably don't want people playing beach volleyball around it. Like to Justice Lehrman's question to your friends in opposition, where can you draw the line? I know it's hard, but.
Right, so I think that both of those situations, once we apply that Robinson police power analysis, both of those are likely to satisfy a legitimate use of police power. We have a dangerous situation. We're not denying access to the beach. We're taking care of the dangerous situation so that the access could continue.
You mentioned SpaceX, but how is it different if it's Sully with a Weber grill, but if it's SpaceX and it's a bigger fire?
Because the fire would not occur if this law had not been passed in that situation. So SpaceX would not be able to conduct its rocket launches, which is the activity that creates the risk to the public and their welfare.
But I thought you said before that permitting and other regulations were okay. Now, maybe some of those come from the county or from the city, but maybe some of them come from our legislature. Now you've got a different line drawing problem, don't you?
So the difference is that there's some very specific regulations that are allowed under the Open Beaches Act. They're spelled out. So it specifically says the county has the authority to require a permit for mass gatherings so long as it doesn't impede access to the beach or public access to the beach. This particular law, it says it doesn't have anything like that. So the space launches could not occur if this law had not been passed.
Why is that?
So without
Aren't they occurring on, are the launches themselves occurring on private property adjacent to the beach?
Adjacent to the beach, that's
Okay.
right. And
so why couldn't they occur absent the law?
Because they need to have a blast zone, a blast radius, and they are using the public beach as their blast zone. And so that's why they're not able to launch without it. That's why they've located right near the public beach.
If they could do that if the law allowed it to happen one time a year, would your argument be the same?
I think the facial challenge would be the same, because the law doesn't say it's only one time a year.
My supposition is, let's say that the law allows it to be once a year. They can do one of these blasts, or they're going to have the blast zone that requires excluding the public from the beach during that time, once a year.
I would say that we should conduct the Robinson analysis and determine if there is a legitimate police power case that the state can make in order to
Your
justify it.
theory is that the Constitution doesn't allow that kind of exclusion for something that the state permits, right?
That's right, Your
So it really
Honor.
would logically be the case whether it's once a year, once a week, every single day. It's the same constitutional argument you're making either way, I think.
That's right, Your Honor. Our argument does focus on the plain text of the amendment, and it uses unequivocal language like unrestricted rights.
If you're right, then why couldn't the courts go ahead and resolve whether it's facially valid? It's just a question of whether or not the state has the authority at all to allow this kind of activity. Because it really doesn't matter about duration, how many times. It's just, does it have that power under Section 33 or not? That seems like something that facial validity of that argument can be determined based upon the briefing that we have, or certainly the Court of Appeals could do. Is that not right?
So the facial challenge, I think, is a legal issue that could be decided. We also have an as-applied challenge, and for that challenge, we do believe it's necessary to go back to the trial court, develop some evidence through discovery.
But if your legal argument is what we've just described, why would that be true? Why would we need to do all of that?
That's correct. I think that that's accurate. If our facial constitutional challenge was right, if our theory is right, then there's no need to go back and develop the evidence.
Is your legal theory that anything that the state plays a causal link in restricting access to the beach, that's the thing that is the constitutional poison? So this law, you say, is what makes it possible to have exercises in which the blast zone would require the public being excluded. So it's the state's conduct in causing that creates the constitutional problem.
Yes, I think that if we start with the plain text and we compare it to the plain text of the statute itself is constitutionally invalid. It just plain allows.
We're thinking about what the Constitution really requires here. At least we're being asked to do that. And I'm wondering if there was a statute that said, for example, it is the requirement of the Department of Public Safety to coordinate simulations of beach attacks that would require local police departments, sheriff's office, DPS to simulate these potential terrorist or criminal attacks, and the public must be excluded, obviously, during that sort of thing. I think that would be a violation of Section 33 under your reading, as you've said it to us, would it not?
It would, but that's where the Robinson analysis kicks in. So if there are limits, as the justices have noted, and when there is a constitutional infringement, it may nevertheless be justified if a showing is made, consistent with the analysis in Robinson, that this is a valid exercise of police power.
If I could just, one last thing on that. I thought that your argument was that would be true if it were two people on the beach doing something or a natural disaster, but if the state is causing the thing that would restrict access, why would we have those balances in? Because if that's true, then I think the whole theory unravels, doesn't it?
I think that on its face, that does appear to restrict beach access.
Okay.
Yes, I'm allowing room for some limits on the scope of it. And if a legitimate showing can be made for police power.
And with Robinson, you're talking about our opinion in Robinson against Crown, Cork, and Seal, is that right?
That's correct.
So I was nodding along when you were talking about the plain text. It's helpful. Everybody here can go print a copy out. Our Constitution is quite long, but we write these things down for a reason. Most people in here are probably old enough that they were founding fathers and mothers and got to vote on what's now the Open Beaches Amendment. But now you've gone from the text to what this court has written in an opinion, and now it seems like it's getting a little bit squishier here. So how do you fit kind of a multi-factor analysis, each one, more pointless than the last, with your plain text argument?
Sure. So I was conceding to Justice Young's question that on the facts that he presented, it does sound, based on the plain text, that would constitute a violation of Section 33. And so I was allowing that even when it appears that there is a straight-up violation of the constitutional amendment, this court has acknowledged that in some instances that the action can nevertheless be justified if a strong showing is made that it's necessary for some exigent circumstance to employ police power. So,
do you think that we were right when we said that in an opinion? I thought it was your brief that was talking about the word inviolate that is in our Bill of Rights. So do you agree or disagree with this court in opinions? It sounds like you're saying basically water it down instead of try to read the text in its context.
I think both are right. I think that both can be reconciled. So we start with the plain text and the history and the structure of the constitutional amendment and determine what it means, the force of it, the scope of it, much like was done in Pettis versus San Antonio. And then separately, if it appears that the statute is not reconcilable with the plain text of the amendment, and the state is suggesting that they are acting within some limit that is recognized under police power, then it becomes their responsibility to make that showing.
Could the government close a portion of a beach for a fireworks show on the 4th of July or New Year's Eve?
I'm not aware if the government closes the beach for such a thing, but...
Well, could they, under your theory of the Constitution?
No, they could not, unless, again, just based on those facts, no. They could not deny access to the public.
How about a few more facts? Could the government close the beach overnight? Let's say they just were going to have some hours, 10 p.m. to 5 a.m., the beach is closed. So just those facts, I think your answer is no, it could not do that, right?
That's right.
Okay. Now suppose that, let's get the police power involved here. Now suppose that the government said, we want to close the beaches from 10 p.m. to 5 a.m. because there have been vandals dumping some toxic substance on the beach, and it always happens at night. Let's say they're dropping orange paint all over the sand. Permissible closure or no?
I think that's where we apply the analysis to determine, is this a valid exercise of police power?
Okay, so just on those facts, do you think that it would be? Because I have one more fact to lay in next.
I think that I think a good case could be made.
Okay. Now, what if the vandals who are dropping the paint at night, who the police are trying to keep from doing that, are doing that in protest of some government action? Mm-hmm. So it is the government action that has caused these bad guys to come and try to ruin the beach. State is now connected to the reason for the closure. It's caused or incited the reason for the closure. Permissible closure now?
I think that it still requires a Robinson analysis, and it requires a showing of a real exigent circumstance that necessitates police power in order to protect the public. And in all of those situations...
And let me, it seems
Sure.
that in Justice Huddle's excellent hypothetical, you're bringing other constitutional issues into play that have to do, like, with your right to voice complaint against the government. So how does that play into it?
So I think that we would have to perhaps engage in a couple of constitutional analyses depending on the way that the claim was brought before the court. Is this a claim that is also based on violations of the First Amendment or of the right to free speech? Now we have a different standard. Is this really just about accessing the public beach? Then that's a pretty unrestricted right based on the plain text.
Turning to the constitutional provision that says that there is no private right of enforcement, and Cameron County's argument that means that the government has to enforce the Constitution rather than individual citizens. We said in City of Galveston versus State that in certain circumstances, a local government can sue the state. Why isn't either Cameron County or a municipality or some other local government the appropriate enforcement actor for this constitutional provision when it's alleged that the state statute violates it?
That the state, we would be glad if the county or or the state or some governmental entity were the ones that were enforcing Section 33. And the Open Beaches Act contemplated that a governmental entity would be the enforcer of the public's right to access the beach. But in a situation such as this, where it is the state and the county and the GLO who are the ones that are impeding access to the beach, then Section 29 kicks in. And there's nothing in Section 33 that says this particular provision of the Bill of Rights doesn't get the same remedy that all of the other Bill of Rights provisions
So your
do.
position is a private citizen can always sue the government to rectify a constitutional violation.
That's right.
You're not seeking money damages, and you're not suing another citizen. You're suing the government itself, who's not abiding by its constitutional obligations.
That's exactly right, Your Honor.
Like an ultra-virus type claim, because this is accepted out of the general powers of government as being part of the Bill of Rights.
That's exactly right, Your Honor.
So let me ask you about the sort of the idea of protecting the public from danger in the easement. I think you agreed that if there were a hurricane coming, the beach could be closed. So why is it different when the danger comes from a blast from off of the public property that's caused by a rocket instead of by natural forces?
So I would say that
Because
first,
certainly
man-made-
it would be dangerous to be on the beach, right, when one of these rockets was
That's
being
right.
launched.
That's
Okay.
right, and we would concede that there are some man-made events that probably are justified under police power, like an oil spill or like a nuclear.
Just not this one. And I
Well,
apologize-
it's not that it's not this one, it's that this is not intended to respond to those events. This is intended to create those very events.
Since your red light's on, a yes or a no will be fine to this. So your position is that the people of Texas in 2009 amended our Bill of Rights to say, like, we can't celebrate the 4th of July by shooting fireworks on beaches anymore?
No, I think that having fireworks on the beaches is fine. The issue is whether the public is being impeded from accessing the beach.
Would you accept a rule that the state can always close a beach when necessary to protect public safety?
I hesitate to try to think of every situation that
Sure,
that could
well,
apply
I guess I'll
to.
put it another way. Can you think of an example when the state could not close the beach even if there wasn't public safety necessity to do so?
Oh, right. I think that, yes, that's what the police power was intended to do. That's what Robinson describes, that talks about an urgent, exigent circumstance where the public is in danger and where we're looking to protect the needs and the welfare of the many, and making as small or slight a constitutional violation as possible. This is the opposite. This is to benefit one entity, and it's restricting the right of access for the many.
If instead of closing the beach, the government set up bunch of signs and said, do not come through here, it's very, very dangerous, we urge you not to do it, and the legislature passed a law that said anybody who's harmed by the blast can't sue SpaceX or the government or anyone else, but the beach is open, it's just that if you're there at that time, you'll be severely injured. Would that arrangement be lawful in your mind?
I see I've got a red light. May
Yes,
I
you may.
proceed? I believe that even that sign could be construed as impeding access to the beach. And here's why. In the
Well,
open,
the sign says the beach is open, but please don't come because it's dangerous for you. So you can't misconstrue the sign as closing the beach.
okay.
Is that a lawful arrangement?
Come on in, but you will be extra crispy.
That's a good one. I think I would have trouble on that one, but because if the purpose of it was to prevent people from accessing the beach, well, there's actually a statute that says in the Open Beaches Act that individuals shouldn't even put up signs that say no trespassing or don't come onto the beach. In your hypothetical, it's not saying that, but there could be a danger. I think I wonder if the space launches could occur if that's the only protection there was. I suspect that the launches would be in violation of the license if they could not ensure that the access to the beach were completely closed because they need it. They need to take possession of it and exclude others so that they can use it as their blast zone.
So it seems like your argument now is extended to even preventing the state from warning citizens to avoid danger.
No, I think that they could, I mean,
Well, you said
that doesn't impede access. I think what I intended was,
Well, you said the sign wouldn't be allowed under your argument.
the sign wouldn't be allowed if it said you're not allowed to access the beach.
No,
I think it's
we-
a closer call.
It says welcome, but understand the risks.
Right, yeah, I don't know that with language like that, I'm not sure that that is denying access to the beach. And for that reason, if it's only saying, come at your own risk, and it's not trying to deny access to the beach, then I think the launches can't occur, is what I'm saying.
Which would probably be fine for your client, but that would then be something to take up with the federal government, I suppose.
That's a decision that's made with SpaceX, and yeah.
Thank you,
Counsel,
Mr.
I have one last thing. I just want to make sure. I think that, we've had 25 minutes with you, and all of it, I think, suggests that the principal issue that the state raised is now basically agreed by the parties, and as the Court of Appeals was wrong to understand that from Klum, it did not have to assess facial validity if it's based upon a challenge to a statute rather than government conduct. And I think all of your answers are premised on the idea that, no, they need to do it, but we should win. But yes, that's the correct, and the outcome would be the same, but you're not defending what the Court of Appeals said about the process that courts should undertake in this situation. Is that correct?
That's correct. I want to make sure to mention that the Court of Appeals did not misstate the outcome or the holding in Klum. And
It
Malk-
misstated the law, you're
right,
saying,
that-
but it got the right outcome.
That's right.
Okay.
And Malk wasn't raised until the motion for rehearing, so,
Thank you, Ms. Morales.
thank you.
Ms. Klusman, you have 5 minutes.
Thank you. May it please the court. I think what the respondents are operating under is a far too narrow conception of what is within the police power of the state. If we look at cases like Lombardo, we cited it for a different purpose, but it also discusses that the police power includes not just health and safety, but the general welfare, the general prosperity of the state. And so that encompasses furthering the space industry. And so what this law does, and you can see it in some of the legislative history, is it balances the public's right to the beach with the state's interest in furthering the space industry, which will, of course, assist and benefit Texas and Texans. And
I struggle with what I hear you to be saying, which is that an unrestricted right is actually a right that can be restricted anytime the government thinks it should be.
that is true for all property rights, Your Honor. As long as it's a valid exercise of police power, the government can tell me what I can do with my property. I am zoned, I can't open a gas station on my property.
But not all property rights say in the Constitution that they're unrestricted.
No, but if I give someone a deed that says you have the unrestricted right to use my property, the government can still come in and tell them, but there are things you cannot do on that
Sure,
property.
because you're a private person giving that deed. This is the Constitution giving that deed.
But the Constitution, the portion that gives the deed says this right is dedicated as a permanent easement. So the right is a permanent easement. The easement itself does not come with restrictions buried in it, but the government can still exercise its police power as it can with respect to all other property with respect to this easement.
If we disagree with you that general welfare should be read so broadly when the Constitution describes the right as unrestricted, do you lose or do you still win?
I mean, if it is truly unrestricted, then the government can never do anything on the beach. So
No,
all of these
I
laws
meant,
are.
as far as your argument about how far general welfare and prosperity goes, do we need to get into any of that, or can we stick with the health and safety issues that we've been discussing?
I mean, I
And
think
does
the
the state
reason-
win under that conception of, you can close the beach for a hurricane or other dangers, and this is a danger, so?
Well, I agree. I think the general health and safety would still cover keeping people off the beach during a launch, but I think we have to go farther to address my colleague's argument on the other side, where she says, well, but SpaceX isn't a good enough reason to close the beach down. And so my point in that was that that's also within the police power of the state to decide that it wishes to further the space industry. So you can just rely on health and safety, but I did want to respond to the suggestion that this idea, and I believe it is Justice Willett's concurrence in Robinson, that we use the needs of the many, you sacrifice the needs of the few for the needs of the many. That's not how this court handles police power questions. And
If we're viewing this as an easement and sort of under the private property rights regime that you mentioned, it seems like there's two ways to think of this, and I wonder which one you think is correct. One is sort of there's a danger that's coming onto the easement, and is there a right to protect the public from that? The other is that there's a trespass that's occurring by the gases and things that are being vented onto the public easement. And, is there a difference in the analysis if there's a trespass on a public easement by a private actor, and how does that, which of those two views do you think is correct, or maybe both are, and is there, if there's a trespass, does that change the analysis?
Yeah, that's probably why I lean towards the first one, because I have not conceived that this case is a trespass by SpaceX onto the beach, because they have had government permission to do so. So that's why I lean to the first one. This really was just sort of a cooperative. The FAA says, well, we're going to need to clear people from the beach, and the state wants to, further the space industry, so it wants to allow people to clear from it was just everybody working together to further the space industry while also protecting the rights of the people to access the beach.
When you were at Baylor Law in the property class, you own it from the center of the earth to the heavens, right? And so the state of Texas owns this beach land, from, Hades, like up to heaven. Is that basically what the state owns? And holds in trust and easement and so forth?
Sure, yes.
And
Your
so your friend in opposition, I don't think, has argued that FAA or anybody else, can't shut down, having drones flying above these beaches in the three-dimensional wedge or whatever?
I don't believe I've heard, yes, I don't think I've heard that, yes. So,
Are the pleading defects that you allege in this case curable, and if not, why not?
I do not believe they are curable, Your Honor. First of all, as far as facial invalidity goes, there are clearly constitutional applications, we believe, to this law, so the facial challenge would fail. And then as far as, if I could finish, the as-applied question goes, again, pages 108 to 110 of their pleadings and the clerk's record demonstrate that their as-applied challenge is said, as applied to Boca Chica Beach. They have not attempted to demonstrate, well, one day is okay, but 15 days is too many, because under their theory, even one day is too many days under their theory of the Constitution. So I don't think that this case can be repled in its current
That seems
form.
like it's saying that the as-applied challenge is nothing but the facial challenge.
I think the same arguments are being applied here. I don't really see a difference. Yes, it appears to be a geographic limitation as opposed to more of a what is, how many hours we're discussing
Why
here.
couldn't that be cured, though? I mean, it sounded like even you agreed that there is some limit, so why wouldn't they be able to come back and make allegations that, well, okay, we're wrong on the facial side, if that's the case, but this goes too far and here's why?
The arguments that they have, or the facts that are in the record or that they have pleaded were a closure of about, I think, 450 hours at most, they said, and then SpaceX, of course, has an amicus brief saying we're even making it fewer these days. So I think 450 hours would not violate the Constitution. I think 450 hours would be within the police power, and so even if that were the basis of their as-applied challenge, it would fail.
We would have to say that in order to deny leave to replead. We'd have to make a holding that 450 hours satisfies the Constitution. Is that really something that we ought to be doing right now?
I think you could say that given the facts that are pleaded and recognizing that the police powers are a very fact and circumstance specific question, that there has been no demonstration that this law does not further the general welfare of the public or that it is arbitrary. And so under the facts that are currently pleaded or even that have been suggested, this law would survive.
Any further questions? Thank you, Ms. Klusman. Thank you to all counsel. Thank you to our very respectful and well-behaved audience. The court will take a brief recess before returning to hear today's second case.
All right.
Okay, another one in the books.
Ladies and gentlemen, if you could please take your seats. The court will be out momentarily. If you could please take your seats and come to order, please. Also, if you would please turn off or silence your cell phones, we would appreciate that. So again, please turn off or silence your cell phones. Thank you. All rise.
Please be seated. (24-1060), the state of Texas versus the city of McAllen and other cities.
May it please the court, Mr. Peterson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you. Mr. Chief Justice, and may it please the court. Standing is the most straightforward way to resolve this appeal. The state of Texas itself, the only defendant in this case, does not enforce either Senate Bill 1004 or Senate Bill 1152. Because there is no enforcement connection to the state, the cities cannot satisfy the traceability or redressability elements of standing, and this court should render judgment dismissing for lack of subject matter jurisdiction. If this court reaches the merits, the most straightforward ground of decision is that the gift clauses at issue are not implicated. The public rights of ways are owned by the state, not by the cities. So the cities are not granting or donating anything of value. To the extent there is any grant or donation, it is from the state itself, not the cities. The statutes also satisfy scrutiny under this court's test from Borgelt and Texas Municipal League. They are not gratuities. The access to the public rights of ways is exchanged for consideration. They serve a public purpose in providing telecommunications infrastructure necessary to the citizens of Texas, and the state retains control over access to the public rights of ways. If this court reaches the merits, we'd ask you to render judgment that the statutes do not violate the gift clauses.
So in cases like this, just for purposes of standing, can you explain or answer the issue about the difference between private claimants and government claimants?
I'm sorry, Justice Lerman, we don't see there being a distinct difference.
Well, that's part of my question.
Between the two. This court's holding in Zarowski, we think, applies equally to municipal plaintiffs as it does to private plaintiffs. Quote, suits brought against the state must be dismissed unless the state official named has enforcement authority. And this traces back, I think, this court in Abbott versus Mexican American Legislative Caucus has approvingly cited the decision of the U.S. Supreme Court in California versus Texas, noting that cases have consistently spoken of the need to assert an injury that is a result of a statute's actual or threatened enforcement. And that's really the key flaw in the city's standing theory here. They are attempting to trace an injury to the statute's enactment. But it's not enactment of a statute that causes an injury. It is enforcement of a statute that causes a cognizable injury.
The cities are going to have to implement this law. They have a legal obligation to do so. And a declaration that these two statutes are unconstitutional would surely redress the injury that the states would have of being compelled to change their conduct in a way that will clearly diminish their revenues and all the rest of it.
So two answers, Your Honor. First, it's not a question of whether a declaration would remedy the injury. California versus Texas notes that remedies act on particular defendants. They don't act on laws in the abstract. So the appropriate question, and one which I'll address in just a minute, is whether a declaration against the state of Texas would remedy their injury.
If we were to issue such a declaration, do you seriously contend that someone else would try to force the cities to do the thing that we've said is unconstitutional?
No, Your Honor, but there's a distinction. The Supreme Court in McAllen versus Brackeen talked about how redressability operates, and redressability must be through judgments, not through opinions, not through precedential force. Obviously, a decision of this court is going to carry precedential weight throughout the state. So in theory, a suit between the city of Houston and the city of McAllen, a precedential decision of this court would necessarily affect all parties throughout the state who would be bound. But we're talking here not just about a decision by this court, we're talking about the jurisdiction of the trial court itself. Could the trial court render a judgment that would redress the injury? And as part of that redressability inquiry, note that we're under the Uniform Declaratory Judgments Act, which cannot prejudice the rights of a person, not a party to the proceedings. That's 37.006A of the Civil Practice and Remedies Code.
So the PUC is charged with enforcing one of these statutes, and so you think a declaration against the state that that the law is unconstitutional would prejudice the rights of the PUC?
Well, we don't actually think it would. We don't think it could affect the rights of the PUC at all. Zorowski tells us that you can't achieve a global injunction, even against all members of the state executive, by filing suit against the state generally.
So what are the cities supposed to do?
Well, there is a real and concrete dispute here, and that's between the cities and the network providers.
So they have to violate the statute in order to test its constitutionality. Even though the state has passed a statute telling them you have to do this, they have to violate it?
No, Your Honor, certainly not. We're not trying to suggest that the Declaratory Judgment Act is unavailable to them. So we think there is a real and concrete dispute between the network providers and the cities over the amount that the network providers have to pay the cities.
So how would that become ripe without them violating the statute?
Well, we think where there's a dispute between them, the city could simply say, we would like to go into court and have a declaratory judgment because we believe that the network providers should be paying us both the fee under the Utility Code Chapter 66 and Chapter 283 of the Local Government Code. We certainly think that's concrete, but I also think these are hard statutes for the cities to violate. I was thinking about what it would look like for the cities to violate these statutes. And keep in mind, it's the network providers who identify the amounts that they owe the cities and remit that money to the city. So if we talk about the city trying to violate the law, I think the only way the city could do so would be by asking the network provider to provide more money. And when the network provider says, no, we're not going to, because the Texas legislature has said we only owe a particular amount, the city could then attempt to sue the network provider and say, well, we think you do in fact owe us additional money. Either way, you have a real and concrete dispute in court between the parties with an actual interest in the case.
Before we move on from jurisdiction, I'm going to ask your friend in opposition to speak to this too. Your opening brief cited the U.S. Court of Appeals for the Fifth Circuit's opinion in Pahlavi. I don't recall having seen it in the bottom side brief. Do you think that there are helpful, persuasive authorities? Can you unpack a little bit, is there any daylight between our federal counterpart and the Fifth Circuit when it comes to Pahlavi?
I don't believe so, Your Honor. This court has certainly said in Mexican-American Legislative Caucus that the Texas standing requirements parallel the federal test for Article III standing. One additional note on being subject to the laws, and I do think this is important. California versus Texas involved standing of individuals. And if you'll recall, this was the case involving the mandate to purchase health care under the Affordable Care Act after the penalty had been reduced to zero. And the individuals raised that same standing argument that says, well, we are subject to the law, we are regulated by this law, the law tells us we must go and purchase health insurance, therefore we have standing to challenge it. And the Supreme Court of the United States, I think, made exactly the same points that I'm making now, which is, no, the mere passage, enactment of a law, even a law that operates on you, doesn't give rise to standing. It is only enforcement of that law that gives rise to standing.
And just to try to ask my question again, I apologize that it was inartful. Is there any daylight between where the U.S. Supreme Court has gone with respect to Article III standing and where the Fifth Circuit went en banc in Oak-Palabi? Not that one could contradict the other, but are there things that are discussed by the en banc court or by separate opinions in the Fifth Circuit that have not yet risen to our federal counterparts?
I'm sorry, Your Honor, I'm not familiar
Okay,
with that at
thanks.
this point.
So does it fix the standing problem if they add the PUC as a defendant?
Not entirely, Justice Busby. So 2 notes with respect to the PUC. First, we think the PUC probably has the authority to enforce this. We're looking at Local Government Code 283.058. The PUC shall have the jurisdiction over municipalities and certificated telecommunications providers necessary to enforce this chapter. We think that probably gives the PUC enforcement authority over Senate Bill 1152. Now, keep in mind, though, part of Senate Bill 1152 affected the charge in Chapter 66 of the Utility Code, and so I think there can be some dispute over if the telecommunications provider is making the payment under Chapter 283 of the Local Government Code, but not making the payment under Chapter 66 of the Utilities Code, whether the PUC would have the authority to enforce that. We think they probably would. We don't believe there's a cure, though, with respect to Senate Bill 1004. That's in Chapter 284 of the Local Government Code, and there's no enforcement authority that we see for the Public Utilities Commission there.
Turning back to Justice Young's questions, do you agree that the cities have some implementation authority in connection with this statute?
I think I'm not entirely certain what is meant by implementation authority, Your Honor. We certainly think the cities are required to comply with them. The Texas legislature did pass a law regulating the amount that they can charge network providers for access to these public rights-of-ways.
And I think the cities say that in Nutsi and a couple of other cases, our court has said that if a local government is charged with implementing a statute it perceives to be unconstitutional, that gives the government a sufficient stake to challenge it. So kind of a different version of standing. Do you think those cases need to be questioned or overruled, or can we rule for you in this case in a way that's consistent with our earlier precedent?
Absolutely, Your Honor. Absolutely, we think you can rule for us in a way that is consistent. We think Nutsi is perfectly consistent with the theory we're pressing today. So keep in mind, Nutsi, we believe, spoke only to the injury element of standing. There's no discussion in Nutsi of traceability or redressability, but there was no reason to, because traceability and redressability were necessarily satisfied there. That began as a suit by the landowner against the appraisal district, seeking to enforce the statute against the appraisal district, to say, I have a right to this particular form of taxation as an ecological laboratory. And the appraisal district, in response, said, no, we think that is unconstitutional, and it counterclaimed for a declaration saying, we think this is unconstitutional, we think you are not entitled to taxation as an ecological laboratory. So you had exactly that same dispute between the private party being regulated by the municipality and the municipality that would present a concrete dispute, just as here, between the network providers and the cities, and in those circumstances, a declaratory judgment would necessarily resolve the dispute between that regulated private party and the municipality itself.
You mentioned that Texas standing law, we have said, is comparable or parallel to Article 3, the way the U.S. Supreme Court has described it. One of the things the Supreme Court has said about Article 3 standing is that states have special solicitude. Massachusetts versus EPI. I believe the Texas Attorney General's office has cited that a few times in federal court.
Certainly.
In terms of us trying to make parallel in state standing law what Massachusetts versus EPA said about federal standing law, what's the state's position about whether cities or local government entities would be entitled to special solicitude just as a matter of general standing law?
We certainly don't believe that municipalities would benefit from that. Municipalities simply have derivative authority from the state. It's the state of Texas itself that's sovereign, so to the extent that there's any special solicitude in the standing analysis, it would go to the state and not to the municipalities.
The analogy breaks down as well.
That's certainly our view. And again, we can accept under NUTSI that there should be a cognizable injury if a municipality believes it is being required to do something that is contrary
That's
to the
true,
state
of course, for any
I think that's
citizen,
right.
right?
But at the same time, we don't think that takes away from the enforceability requirement. That again, this court is reviewing the actions of the executive branch in enforcing the laws.
Is your answer to Justice Young's question the same with respect to counties rather than municipalities?
Yes, we would say counties as well should not
And
receive.
home rule cities?
We would also suggest should not receive the same special solicitude as the state itself. I don't believe this court has adopted any provisions for special solicitude in the standing analysis for any entity. If I can turn very briefly to the merits in the time remaining. I mentioned there are two gift clauses at issue here. They've raised challenges under Article 3, Section 52A and Article 11, Section 3, both of which concern grants and donations by local governments. But in this case, it's undisputed the public rights of ways in question are owned by the state itself. So there's no grant or donation here by any municipality, by any county. Any grant or donation here is being made by the state legislature. We see this most clearly in Senate Bill 1004, where the state noted it was acting in its capacity as a landowner in passing the bill. If we get to the Bourgelt Texas Municipal League test, we do think all three prongs are satisfied here. This is not a transfer of public funds. This is access to public property, the public rights of ways owned by the state. There is consideration that is exchanged for it to the tune of tens of millions of dollars a year. There's no suggestion here that there would be a failure of consideration, that this is simply a gratuitous gift. There's public purpose here. The Texas legislature concluded for Senate Bill 1152 that when one access line is used to provide multiple services, both telecommunications and video service, that the provider should only pay a single charge for that access line, that we want our network providers to develop more and innovative services, and that it benefits Texas consumers by having these additional services provided over the same lines and not double text. And finally, the state retains control over the public rights of ways and could amend, modify, or repeal Senate Bill 1004 or 1152 if it didn't serve the public purpose.
Any further questions?
Just one, if you know, most of the public rights of way that we're talking about, are they owned in fee by the state, or are they owned in fee by a landowner, a private landowner, but burdened by a public right of way?
We're talking about the public streets and roadways primarily, and so my understanding is that they are owned in fee by the state, but I could be wrong, Justice Busby.
Thank you, Mr. Peterson. We'll hear from the respondent.
May it please the court, Mr. Heath will present argument for respondents.
– 150 years ago, when the legislature, or rather when the Constitutional Convention of the time was writing the current Constitution, it was well aware of the problems that arose when cities and counties were all trying to give property and money to the various railroads, hoping they would come through that community. And that created real problems. And the people drafting the Constitution provided in 3 separate sections to say, we don't want that to happen anymore.
You're talking about Article 5 of the Texas Constitution of 1876, is that right?
No,
sorry. You're talking about the Texas Constitution of 1876, right?
That's right.
And Article 5, Section 1 vests the judicial power in this court and in our hardworking colleagues. So jurisdiction always comes first. Could we please start with jurisdiction?
Well, yeah, right, jurisdiction, that's what I'm ultimately going to get to.
Gotcha. Right.
Very quickly, but to say that the constitutional provision involved here is Article 3, Section 52, which says the legislature shall have no power to authorize any city to grant public money or thing of value in aid of or to any corporation whatsoever. And so that's what we're talking about in the 2 statutes that are being challenged today, Senate Bill 1004, 1152, do exactly that. Now, as Justice asked, standing is something we have to consider, and certainly that has been the issue presented by the state in this court. Not so much, in fact, not at all, in the district court or the Court of Appeals, but here the issue has become standing, and obviously we need to address that, and the court needs to address that
Right, because
first.
even if OSG hadn't raised it for us, we would have a sua sponte obligation to catch it for ourselves as part of the oath that we've taken.
Sure.
So, thank you.
And in standing, most recently, the court has used a three-part test that comes from Lujan, the Supreme Court case, Lujan versus Defenders of Wildlife. First issue is injury. And here, I think it's very helpful to look at, in fact, for all parts of the test, with the Nutzi case. The state says, well, Nutzi just considered injury, and that's all, and you don't need to consider the fact, or it really didn't address the other parts of the test, which are traceability and redressability. I think that's wrong. Nutzi
Is the state of Texas the only defendant?
is, pardon?
Is the state of Texas the only defendant that's been named at any point?
That's,
in this
that's
case?
correct.
So in the previous case, you might have noticed that the defendants who are now the petitioners include the General Land Office and Commissioner Buckingham in her official capacity. Would you say that that was a mistake, or that's sort of useless? There's no reason to name them. They could have just named the state of Texas because they're complaining about the constitutionality of a statute?
Well, I think that the state is the relevant party here, because what we're talking about is the constitutional provisions. Is the legislature has no authority to make this law. Now, finding, if this were an alcoholic beverage case, then, the ABC is probably the logical party to name. If it's one involving the beaches, maybe the General Land Office, which I think was the party in the last one.
Do you think the legislature ever has authority to pass an unconstitutional law?
The authority has to do which?
To pass an unconstitutional law? Does the legislature ever have authority?
They
to
have
pass?
no authority to pass an
All right, so why wouldn't the
unconstitutional.
state always be the proper defendant under your theory if someone's challenging the constitutionality of a state law, as in the prior case?
Well, the cases deal with that, in many cases, with the ultra-virus exception. And, looking to a individual public officer that has done that, then you name that person acting in their ultra-virus capacity, you sue them.
Ultra-virus, we're talking about, Judge Ray Randolph famously said jurisdiction is a word of many too many meanings. That's a different jurisdictional thing. First, we're trying to see, is this the judicial power? And so, it seems like under your theory, another caption for the petition that you filed in the district court could have been City of McAllen v. Senate Bill 1004 and Senate Bill 1152, but you wouldn't have standing to do that, right?
I wouldn't have what?
You wouldn't have, there would be no standing for the case City of McAllen versus Senate Bill 1004, right?
Well,
If it sounds silly, like it's supposed
right,
to.
right.
But,
You have
but
to follow
if I understand your theory is that you're saying we held in Nutzi that you can fix that, and instead, City of McAllen just replace Senate Bill 1004 with the state of Texas, and then boom, everybody's off to the races?
Right. Well, if the state does something that is unconstitutional, who do you sue in this case? Is it the legislature? I don't think you can sue the legislature. You don't have a particular member of the legislature that you can sue, but the state is doing something that is patently illegal.
Well, the response from the state is that your disagreement is really with the private companies. You have a disagreement with them about all things considered, both the statute and the Constitution. How much money are you obligated, or how much money are they obligated to pay? And so your disagreement's with them, and you should litigate with them which law applies to the calculation of these amounts.
The injury that is most relevant here, and it's the one that this court in Nutzi identified, which is that if you're a governmental subdivision and you are required to implement an unconstitutional law, you have standing to raise that. And the state, as I understand, said that Newtsy is correct, at least as far as injury is concerned. Now, in Newtsy, they went beyond that and saying that in that instance, it provides the district with a sufficient stake in the controversy to assure the presence of an actual controversy, that was the injury, and the declaration sought will resolve it. And so they wrapped up injury, resolution, traceability. And that's what's happening here. The statute says, cities, you have to implement this statute. You have to give parts of the right-of-way or access to parts of the right-of-way to these companies, either without charge or at a very small nominal charge far below the value of what is being transferred. And the cities, the state has raised the question and said, well, nothing is being transferred by the city because the state is the ultimate owner. However, the statutes say that the cities have full management and control of the land or the property above and below the public right-of-ways. Also, they are the manager of the right-of-way. So even if the state is the ultimate loaner, the city's the one that fixes the potholes. It's the one, and most important here, that grants a permit to the telephone company or the cable company or whomever to come in and disturb the right-of-way and to occupy a part of that. And that's all done by the city. The city takes that action. They're required to take that action. And in doing so, they are required to take action that is in violation of the Constitution. And that is an injury, and this court has said that in Newtsy and the cases that followed Newtsy, Neely, Proctor, and others.
In some ways, these statutes at least seem to operate as a cap on the total amount of fees and taxes that the government writ large can charge. Why is implementing a cap on the total amount of revenues that can be gained from any one sort of utility operator, why does that constitute a gift?
Well,
It's just saying we're not going to charge as much.
right. This sort of fee, by the way, is what at least the Federal Fifth Circuit has made clear that it's essentially in the nature of rent. You know, you're coming in, you're occupying property, and you're paying for it.
Right. You might pay a fee or rent or something like that. You might pay franchise taxes. You might pay some tax on revenues. And all of these things are all monies flowing into the government.
Yep.
Why can't the government say, okay, because you're paying this much over here, we're not going to charge this fee?
Okay, and this is something that is a fee for a particular service or a right to use a particular thing, and that has a value, and it
All
is...
of these things presumably have value.
Well, that's correct, and in this one, in the summary judgment that was submitted by the state in the district court regarding 1004, Senate Bill 1004, they had to accept the proposition for the purpose of the summary judgment that value was $2,500, between $1,500 and $2,500, because that's what was alleged in the petition, and they had to take that as true and say, well, we're offering it or we're giving it for $250. So you have the right to occupy the right-of-way, which has a value that the court had to accept of $2,500.
How is that
And we're
value-
giving it to you for 10 cents.
How
on
is
the
that
dollar.
value calculated? I get it in this procedural posture, we accept $2,500, whatever, but
Yeah.
how would that value actually be ascertained if we needed to know what the real value was?
Well, if in 1004, which I think that part of the case goes back to the district court, not 1152, but in 1004, we would have to put on testimony, and we would have an expert. In fact, there's an expert affidavit attached to the petition, and who says, here's what this is valued
Market
at.
value,
And
basically.
from all over the country, here's what was being charged, and here's how to compute that, and it would be through expert testimony, and that much is in the record. I can get into other things we could put in the
That's
record.
right. So at some point, using expert testimony, statistics, econometrics, whatever, we get to some number. Here's the true market value of this.
Yeah.
The legislature says $250. So the delta between that, your theory is that it's a gift, right?
Yeah, well,
And if a city, let's suppose we had that same market value that we could get through expert testimony. If a city was charging maybe much more than $250, but less than that, would that be a gift by the city that would also be in violation of the gift clauses?
well, I think it depends. And, for example, our position, or our expert's position, was that it was between $1,500 and $2,500, and it varies. And, it may vary with the particular area or the particular city, in many other
But if we could prove
instances.
that in McAllen, this is worth $5,000, people would pay $5,000 for it, and McAllen only is charging $2,500, would that be a $2,500 gift clause violation by the city of McAllen?
If it was clear that that was the violation, or the value. But the other thing is, sometimes this is accompanied by other things. You're paying X amount, and by the way, you're putting this line in an area that's beneficial to the city, that's specifically doing underserved areas that you wouldn't serve.
Why isn't that enough to take this whole statute outside of the gift clause? In other words, I think the state argues, and you seem to be conceding, that the city accepts some benefit by allowing the use of its right-of-ways for utility infrastructure. So for this auditorium is powered by infrastructure, and to the city, it's a value to government. So why doesn't that just completely take it out? It's no longer a gift. Now, maybe the consideration bargained for is a little unequal, but it's no longer a gift.
And this court has specifically told us how to analyze that, and that's from the Borgelt case, which is fairly recent. In fact, it came out after it was briefed this case was briefed in the Court of Appeals before the Court of Appeals ruled, or the TML case, which was somewhat earlier, and both of those give us guidelines to look at to see if a gift is permissible.
We also need to look at the railroad context. You mentioned the railroad context of the gift clauses, and so presumably in those cases where the right-of-way was being given away, it was very beneficial to the cities and to the state that the railroad go through certain towns, and they could expect tax revenues and that sort of thing. So help us figure out why the gift clauses bar that, but maybe they do or don't bar this circumstance where something is being charged, and you can also expect the same collateral benefits that would come from the railroad going through your town. But how do we draw that line?
Well, I think the line is set out in Borgelt, where there has to be a public benefit, and it has to be something, not gratuitous. So you have to get some sort.
Well, it's not gratuitous here because they're charging something. So that when does it become gratuitous?
Yeah, well, and then the next issues in Borgelt are the public purpose has to be predominant, even though there is a private purpose. And here there's a private purpose, and that's okay, a private benefit to the phone companies and such.
Is there anything in the text of our Constitution's gift clause provisions about what predominates or anything like that? Or is that in opinions that our court has written?
Well, I don't think there's anything in the Constitution that says
Right.
what predominates, but under the Borgell test, the public purpose, say, has to predominate, and the obligations that are set out that you're looking at to find the public purpose, it has to be in the statute. The
Yeah.
statute has to require it. It's not the fact that
So-
serendipitously it just happens.
If I could come back to the question that you were speaking with Justice Young about, and I want to be very clear, this is a hypothetical question, but I think you said we'd need econometricians and, property, realtors, whatever. You said that the range for these easements is probably between $1,500 and $2,500? Is that roughly?
Right.
So suppose hypothetically that it's going to cost $10,000 per easement in hiring econometricians to do this. Does, whether it's the city of McAllen or the state of Texas, do we have to protect like taxpayer funds by spending 10,000 taxpayer dollars to value a $1,500 to $2,500 easement?
Well,
And if not, why?
If it was going to cost $10,000, I think we would certainly argue that the city could require that sort of payment if that's something the city was having to put out. So yes.
So why can't our legislature, instead of valuing each easement in each city, in each town, in each municipality, in each home rule city, do it at scale and say, instead of spending lots and lots of taxpayer money to figure out what this stuff is work, this is, good enough for government work? Why can't they do that in the legislature?
Well, but underlying it all, it has to have a predominant public purpose, has to be provided for in the statute. There is no obligation in the statute
Can the
at
public
all
purpose-
in this case.
Can the public purpose be reducing the amount that citizens and businesses pay on their phone bills and their cable bills?
If that might be a public purpose to say, there's a savings for the citizens, but the statute doesn't require that. And in fact, during the legislature consideration of Senate Bill 1152, there was an amendment not to require that it be rebated in the phone bill, but to say, report to us what happens with those savings. Does any of it go to the cities? Make a report. And the legislature said, we're not even going to require you to do that. Essentially, do whatever you want. You don't have to answer to the state. And the last part of Borgelt is that it has to be enforcement or control kept by the state. And there is absolutely nothing here. The state said, well, we can always repeal the statute. If that were the case, the requirement would be meaningless.
Any further questions? Thank you, Mr. Heath. Mr. Peterson, you have 5 minutes.
Thank you. Justice Busby, City of Mission versus Popplewell states legal title to city streets belongs to the state. With respect to the argument that the gift clauses speak in terms of the authority of the legislature, I'd point the court to the First Amendment to the Constitution of the United States. Congress shall make no law. There's no suggestion there that Congress is a proper defendant as opposed to the executive branch officials charged with enforcing the statutes that are alleged to violate the U.S. Constitution. With respect to NUTSI, this court's opinion notes the appraisal district as filing two things. One, a counterclaim against the landowner, and second, it states that the district filed a third-party petition naming the Attorney General of Texas as a third-party defendant. On that same page, in its discussion of standing, this court talks about standing only with respect to the counterclaim. There is no discussion of standing in NUTSI at all with respect to the third-party petition. We just don't see how NUTSI provides any analysis, much less any holding, with respect to any claims being asserted against the Attorney General or the state in that case.
To what extent are the rates charged to customers by the companies we're talking about regulated by the PUC or otherwise?
The per-line access rates are set by the Public Utilities Commission under Chapter 283. For the network node fees under Senate Bill 1004, that's the $250 per year cap placed in the statute itself.
I'm talking about the rates, the bills that customers have to pay.
I don't believe the overall rates are set. I believe the per access line additional charges are set by the Public Utilities Commission, Your Honor. In that regard, with respect to the amount of charges, Bourgel states that you don't need to have equal consideration to avoid a violation of the gift clause.
Would it be a gift clause violation if instead of $250 it was zero?
In these circumstances, no.
Just because of the state's ownership?
Because of the state's ownership.
The state can't violate the gift clause either, though.
That's right, but there's a critical difference between Article 3, Section 51 and Article 3, Section 52A, and I think this is important to the railroad context that the court was talking about. Municipalities were being taken advantage of by railroads, and we see in Article 3, Section 52A a prohibition on authorization of municipalities to grant public money or anything of value. We see a much narrower restriction on the Texas legislature itself in Article 3, Section 51, which prohibits only the granting of public monies. So just looking textually, these are public lands controlled by the state. There's no suggestion that the state is giving away public monies here. But
so the state can give away public land for free?
My understanding, Your Honors, in fact, that did occur in the early days of the Constitution of 1876, that there were, in fact, grants of public land to settlers and I think also to railroads as well. I believe the original Article 14, Section 3, I think it's since repealed, did authorize grants of land to railroads.
The Constitution itself governed that, but in terms of just a general thing, like Justice Busby, I think, is suggesting, is your idea that the state could maybe have a big repository of diamonds? Well, we can't give public monies, but I tell you what, diamond for you, diamond for you, diamond for you.
Certainly, Justice Young, if that ever occurred, we think this court would be able to see through the form of the transaction and look at its substance.
All right, so if that's true, then why doesn't that have the same effect? You know, there's something that we were charging you for, we decided not giving you any public monies. I mean, it's the same thing, isn't it? Like a refundable tax credit of some sort is still money, right?
I wouldn't think so in these circumstances. There's a difference. I took your diamond hypothetical to be the state purchasing diamonds with public funds and then transferring those diamonds to individuals. I think if those cases, the state is essentially just evading the prohibition on transferring public funds. In this case, there's no indication that the state is attempting to transfer public funds.
If we had a Texas diamond mine and we just got the diamonds, no problem, because we're not buying the diamonds and then giving them to people, but we could give those diamonds away for free to anybody without a violation of the gift clause because it's not technically public monies. Is that what you think that means?
That hypothetical, I think that would probably be correct. We haven't explored that, Your Honor. I'll say the easiest answer here would be to say not that this doesn't violate Article 3, Section 51, but to say that no violation of Article 3, Section 51 has been pleaded. I do think there are important textual differences between Article 3, Section 51 and Article 3, Section 52A. I'd also note State versus City of Austin dealt with charges to charges to relocation of utilities, and it did reject the idea that the state is required to charge as much as the market will bear. In those circumstances, the state was able to pay costs that the utilities could otherwise have been required.
Any further questions? Thank you, Mr. Peterson. Thank you to all counsel. Thank you again to our audience. We will adjourn and then return in a minute to have a conversation with you. And with that, the marshal will adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned. Ladies and gentlemen, we will have a question and answer session here in a few minutes after a brief break, and we'll be working with the staff here to make microphones available to you there in the audience if you want to ask a question. This is a great opportunity to ask the court whatever you want to talk to them about. But this is an important point. The court cannot talk to you about the cases that you just heard. So this happens every time. I tell everyone they can't talk to you about the cases, can't answer direct questions about these cases you just heard, and someone will ask about it. So we'll be back in just a few minutes.
Can I make an announcement about the school? Yes. So much for attending. For the K-12, can you please just sit tight and we will do dismissal after the Q&A?
And witness this. The court has a very limited amount of time to answer questions. And so I'm going to task your schools with figuring out which of you have really great questions. And we're going to take 3 or 4 students who have these great questions to ask. You're going to come and line up over at the side, and then you're going to come up to the podium as if you were arguing to the court, and you're going to ask your question. A lot of you are in debate. A lot of you are in mock trial. A lot of you may be thinking about a career in law. Maybe none of you are, but after today, you might be. Okay, so quiet down for just a second. Quiet down for just a second. When your administrators decide if there is one amongst you who has this excellent question, they're going to come over here on this side and visit with us so that we can only pick 3 or 4. So the court will be out in just a few minutes. You have like 60 seconds to figure it out, okay? And then meet us over here.
Okay, all right. It looks like we have enough volunteers already, so we're done with volunteers. No more volunteers, please. I'm sorry.
Good afternoon, Justices. I hope you guys have been enjoying your stay here at the great University of Texas, Rio Grande Valley. I'm actually the Vice President for the student body here. And my question is about, so this year, one of our student senators passed a bill that the student body is in support of establishing a law school here at the University of Texas, Rio Grande Valley. And part of the reason of that was because the Valley has been established as a large metropolitan area. And that was actually one of the reasons why UNT got established a law school. So I wanted to hear you all's thoughts about establishing a law school here in support.
That's an excellent question, thank you. And the court oversees the legal profession and the regulation of the legal profession, which includes law schools in our state. And so we're very interested in making sure that legal education is available and we have enough lawyers to meet the needs of our state in all parts of our state. A new law school is an undertaking, for sure. It would require a lot of effort, a lot of people, perhaps a lot of money. But it's something, this is the 5th largest metropolitan area in the state of Texas. And we don't have a law school south of San Antonio. We have a long way to go from here to there, but I don't see any reason why that shouldn't be a goal of this community, perhaps this university, and certainly the legal community in this part of our state.
Thank you, Chief Justice. And I would like to add that we do have a lot of ambitious young students here that do want to be lawyers. Thank you for your time.
Thank you very much.
Good morning, Justices. My name is Alicia Ting. I'm a representative of Idea Elsa College Prep. My question to you is, while you're up here in cases such as these, how do you manage to conversely talk to the attorneys while still keeping legislator in mind all on the spot?
Justice Bland?
So it was, first of all, thank you guys so much for having us. We're so grateful to be here today with you. Your question was, how do we keep the legislature in mind, or the...
So while you guys
while
are talking...
we answer questions with the attorneys?
Yeah.
So as Chief Justice Blacklock pointed out at the very beginning, we have written briefs that you guys can see online on the website that educate us about the arguments that are going to be made. So unlike you guys, we already kind of knew. We had a preview of what the arguments were going to be. And to your point about keeping the legislature in mind, we look at the state statutes that are important to the case, and they're going to be copied right into our briefs. So we have them, and we can refer to them again and again. And most of us have notes up here that has the statutory language right in front of us. So you heard, I think, Justice Busby ask a question about restricted, and that came right from the Constitution, or unrestricted, I think. So we're constantly evaluating the answers that the attorneys give us in argument against the state law that the legislature passed that we have in front of us.
Okay, thank you so much.
So you all were at a disadvantage because you hadn't seen all that before, and it didn't give you the context that we have.
Okay, thank you, Justices. Thank you for this opportunity.
Thank you.
Hi, good afternoon, Justices. My name is Ana Marlene Chanes, and I'm here with Hannah Early College High School. So my question for all of you is that I noticed there was a lot of hypothetical questions made. So I just want to know, in any case, what is the purpose or effect of making those questions?
Justice Lerman, would you like to answer that?
Thank you. That's an excellent question. So remember that the Supreme Court is the court of last resort for all civil cases in our state. And one of the main, and it's a court of discretionary review. And so one of the main things that we look at is whether or not this case, when we decide whether or not to grant review, is going to substantially and significantly affect the jurisprudence of the state of Texas. That's very, very important. We don't take cases that just affect the people who are here. And so when we ask those hypothetical questions, we're getting at, well, yes, and you heard today that the attorneys would say, well, in this case, in this case, in this case. Well, we're certainly very, very interested and concerned about the parties that are affected and the people of this case, but we're also very concerned about all of the people of Texas. And there's going to be other cases that will involve similar issues, but not exactly the same. And that's the reason that we always ask hypotheticals, because the last thing we want to do is issue an opinion that inadvertently affects something similar but different in a way that we did not intend. So that's the reason those hypotheticals are very important, because we're dealing with cases that affect every person in Texas.
Well, thank you so much.
Thank you.
Good morning, Justices. So my question is, considering the Texas Constitution, how do you stay loyal to the original text and laws, but considering the modern situations and times of these cases and current cases?
Justice Young?
That is a great question. You probably know, and I think it was even referenced in one of the arguments today, that this is a very special year for the Texas Constitution because the Constitution took effect in 1876, and here we are in 2026. There's a long, fancy word for that, sesquicentennial, or I like to call it the Texquicentennial for our Texas 150th anniversary. And we all should be so proud that our Constitution has endured, and it's gotten very long. And so one of the reasons it's gotten very long, and I should probably tell you how long it is, excuse me, when our Constitution was promulgated in February of 1876, it was 22,000 words, which is pretty long. The United States Constitution, with all of its amendments, is 7,600 words. So we're already 3 times longer than the Constitution today of the United States back in 1876. 22,000 words is roughly the length of a Shakespeare play. Our Constitution today, as of the last amendments that we made, which was in November of last year, 17 amendments were approved by the people, is now 110,000 words. 110,000 words is half the length of Moby Dick, and that's our Constitution. So when you ask the question about how we understand really what it means, what did it mean when it was written, how do we address it in its current circumstances, it's actually a very complicated question because our Constitution, despite originating in 1876 and being the same Constitution, has been changed almost every other year for 150 years. So some of the provisions of the Constitution, we look at them, and it wasn't the people in 1876 that adopted them. It might have been the people in 2021 or even 2025. People in this audience have been the decision makers about whether our Constitution would change. So the first thing we have to do is figure out what did these words in our Constitution, what did they mean to the people of Texas who exercise the sovereign power of changing our highest and most fundamental law, which is our Constitution. And whatever those words meant to the people who adopted it, they must mean the same thing today, whether or not they were adopted in February 1876 or November of 2025. Because until the people change the Constitution again, as they do all the time, that's why it's so long now, the law cannot have changed. They're the only ones that have the authority to change it. So if the words mean something different today than they meant when it was enacted, who's doing the changing? Is it the judges? We don't have the power to change the people's law. That belongs to them, not to us. Now, the second part, though, is very complicated, too. And that is, we might be able, after a lot of work, a lot of effort, a lot of reading, that's why most of us either are wearing contacts or have glasses, we have to then apply that law, once we figure out what it means, to circumstances that might have been unimaginable to people in 1876. And fortunately there, usually the Constitution provides principles. It provides rules. And we can take current circumstances, a world that did not exist then, and still apply it. And the U.S. Supreme Court does the same thing for the federal Constitution. There was a famous case about search and seizures. And of course, the general rule in the 1700s, when our Constitution and Bill of Rights, when they were passed, when they were adopted by the people of our country, was, well, you can't go into people's houses and see things unless you have a warrant. So then in the 20th century, new technology was developed. We're using thermal imaging. People could essentially see what's going on inside your house while standing on a public street. Well, the Fourth Amendment, they couldn't have anticipated thermal imaging to see if people were growing marijuana plants or something like that. And so, yeah, well, I guess then the government can do it because they're on the public street. And the Supreme Court said, no, the principle of the Fourth Amendment is very clear. The government cannot invade your house. It doesn't matter what technology it uses to invade your house, and that principle applies. Sometimes, though, it doesn't work. Sometimes the Constitution simply does not give the government authority that it might need. And that's why our Constitution allows the people to fix it. And our job as the court is to do our best to tell the people of Texas what their law is, not what it ought to be, not what we wish it was. Sometimes we really don't love the decisions that we have to make. But that's why the people get to rule themselves by sending people to Austin in the legislature who can propose amendments, and then all 31 million, those who are registered to vote and actually show up, by the way, don't forget that, students, they get to actually make the law.
My name is Luz Morado with Jimmy Carter Early College High School, and thank you for having me.
Could you say that again? I couldn't hear you.
I didn't mention in the beginning, but my name is Luz Morado, and I'm with Jimmy Carter Early College High School, and thank you for having me.
Thank you.
This will be our final question.
Hello, Justices. My name is Joaquin Rodriguez, and I attend high school at Portisville Early College High School. I had actually attended the student legislative session earlier this school year, and as it was quite interesting, I just was wondering if y'all had any direct advice for if I wanted to pursue in your career path.
Justice Huddle.
It's a great question. I think if you had time to talk to each one of us, all 9 of us would have very different careers, very different career paths that we've taken, very different motivations, but I think there are some places where you would hear all 9 of us give you the same answer. I would say talk to all of the people you can who are in a position you would like to see yourself in the future. Try to get out of your comfort zone and say, approach a person who is older than you, maybe not someone you know very well, and say, I would like to learn more about this. Could you talk with me about it? I would say also, aside from that, you should read a lot about what we do. You should start with the Constitution, with some basics. You could go to our website and read some opinions that are of interest to you. And I think, you know, our job is it's fascinating. We deal with really interesting cases, really difficult questions every day, and there are some things that are difficult about that. We spend a lot of time reading. We spend a lot of time thinking. We love writing for the most part, all of us. So ask yourself, is that what I love? Is this for me? And then I think I would, besides sort of the skills, the hard work, the reading, I think you should ask yourself, what do I see is my purpose? What do I feel like I'm responding to a calling? Do I feel like this would be a good way to contribute, not just to myself and to sort of be a breadwinner for my family and be a provider, but is this a good way for me to contribute to my community, to the larger community, the state, however you conceive of that? I think that you would find that all of us sort of have a conception of this being a way that our skills match our desire to sort of contribute to the state of Texas and into the body of law. So I think start with reflection, do hard work in reading, and then also reach out and ask the people around you for help in trying to figure out the best path for you.
Thank you.
Thank you. I think that was our last question, and I just want to say one more time, what a pleasure and a privilege it's been to be with you here this morning to hold these arguments in the Rio Grande Valley. We could not be happier about being here and could not be more grateful for the way that all of you have welcomed us so generously. So one more time, thank you to everyone here at UTRGV and to the entire community. I'll say one more thing and then we'll go. We as judges take an oath to preserve, protect, and defend our Constitution. These lawyers that you heard from today took that same oath. And you may not have taken that oath, but you as citizens share in that obligation, a common obligation that belongs to all of us to preserve, protect, and defend our Constitution, not just for ourselves and our own personal interests, but for our fellow citizens, for the people around us, and for the future generations who will come after us and who we want to benefit from the same blessings that God has given us. And I felt that spirit in this room today. I urge you to go forward out of here with that spirit in your hearts. Thank you for being here to support the court and to support the law. It's been a privilege to be with you.